Hello, everybody. I am just sharing. I forgot to do that last week. So give me just a minute to finish doing that. Squish me. Can I please share? Thank you. It's going very, very slow. So while I'm waiting on that to post real quick, just want to remind you guys, we're going to be reading more of this tonight. I think what we're just going to stick to tonight, it's going to be 2 parts of this. We did how long it took me to read this on just the purple in here last week. So we're going to start with premarital issues, and I'll take a break, from reading and talk to you for a minute. And then we're going to go over marital agreements, take another break, and then I'll finish it off with marriage. And then next week, I will read marital issues, termination of marriage, and domestic violence. So that is what is on our agenda tonight. I just realized I shared this to the wrong group. Not necessarily the wrong group, but I normally share it to the CPS reform group and then share it from there to the Life After Loss group, because for some reason the settings in the Life After Loss group do not allow me to share from that group, whereas the CPS reform, answering any of your questions that I'm going to be doing this week. Saying that hold on. It's acting like my internet connection is rough, so let me turn off my PlayStation. Wi-Fi is so exciting news for this week is that I'm starting a new series on the channel called Becoming the Warrior. And I hope to have the first video out by Wednesday. But the first video is going to be Becoming the Warrior, Healing the Inner Child. And basically what it's going to be about is me discussing or telling things that you can do to heal and become, your own warrior. And so to me, that's the first step, is healing the inner child. And I will talk more about that in that video. Again, the line is open for the phone number. Sorry that it's backwards, but I will write it in. $21.69. I'll write the phone number in the comments. Feel free to text or call. And if you are connected to me on Facebook, then feel free to message me. So I'm just sharing the number again. And then we will get into tonight's reading. Also, feel free to share your thoughts about me doing this law stuff on the lives. Because I do have a lot of things I want to talk about, but I feel like it's also important to read some of the laws. But that's pretty much this. And this, the one for evidence, are the only ones that I'm actually going to be reading with y'all. I'm not really sure when I'll start on this one, because after I read this, after we get done with this week and next week, I want to take a break from that and just, kind of sit and chat with y'all and catch up on some things. And then by then I'll know more about how you guys like the new series that I'm going to be doing on the channel, Becoming the Warrior. And we will talk more about that, not next week, because we're going to finish this up next week, but the week after that. So when would that be? Would that be our first December live? No, next week will be the first December live. So it'll be the one after that on December 9th. All right. So anyway, we're going to get started with the laws with premarital issues. I'm going to read this section here, and then I'll stop and talk to y'all for a minute, check for messages, things like that, read comments if you leave any comments, and then I'll read this section and pause again. Okay. So, premarital issues: courtship, breach of promise to marry, actions generally abolished by Tooth, heart bomb, anti-heart bomb legislation. 2, recognized in minority of jurisdictions where action generally rooted in contract and tort with hybrid remedies. That's something I've actually never heard of. Gifts and contemplation of marriage, restatement of restitution. 1, no restitution from expectation that existing relationship will continue, or from unrealized future relationship unless gift is conditioned on marriage. 2, fraud relief granted where purpose of marriage is to receive gifts. 3, engagement ring, family heirloom, other gifts. A minority fault-based approach to restitution of gift. B, majority conditional gifts turn to donor when condition marriage not met. So I guess that's basically saying that if someone gives you an engagement ring, then you are supposed to give it back to them if you don't marry them or they don't marry you. I've never had that issue because I always bought my own engagement rings. They think they needed to give the ring back. So seduction. 1, recognized in minority jurisdictions, may serve as both criminal and civil cause of action. 2, generally reformulated as tort of fraud. 3, recovery of foreseeable reliance and emotional or physical injury damages, not expectance damages, mix of contract and tort remedies. 4, defenses. A, fraudulent misrepresentation or concealment. B, physical and mental defects. C, mutuality of decision to terminate relationship. D, individual married at time of engagement. Cohabitation. Now, this is the important part, I feel, for most of us, because in today's time, cohabiting is very common. I have done it 3 times now. The third one, Not really. We didn't, I don't really count that as one because we didn't have our own place, but we did share a room in a house, I guess. But technically only 2 times that I actually had my own place and a person moved in with me, all that, and we lived like a married couple, like exactly like a married couple. So this one's going to be important for everyone who is in that situation. Cohabitation. Traditional approach. 1. Refusal to enforce contracts between non-married partners involved in illicit relationship. A. Generally, these relationships receive little or no legal protection from the state. Cohabitants cannot access relief provided to married parties under state dissolution of marriage statutes. B. Recognition and enforcement of agreements where proper consideration exists. C. Property by applying state property and contract laws unless state has enacted specific statutory remedies for qualifying relationships. D. Property agreements between unmarried consenting adults may be enforceable where the agreement is not explicitly premised on an illicit sexual relationship. Marvin versus Marvin, I believe it's California, 1976. Types of agreements include express written contracts, express oral contracts, implied in fact contracts, and equitable, no, sorry, not equitable, that's a different thing, equitable contracts. C. American Law Institute, ALI, treats domestic partners similarly to spouses' property and support purposes where they share a primary residence and life together. F. Many states continue to criminalize cohabitation for unmarried persons and also punish sodomy and fornications of unmarried persons, even though the U.S. Supreme Court has held that a Texas statute criminalizing intimate sexual conduct between consenting same-sex adults was unconstitutional. So, apparently, in a place like Texas, I guess it's saying it's still illegal to cohabitate. I did not know that. Modern trend. 1. Recognizing individual claims of unmarried cohabitants to property jointly accumulated. Minority recognize same-sex relationships primarily by statute. 2. Absence of express writing. Courts recognize other remedies such as implied contract, joint venture, constructive trust, and quantum meruit. It's MERUIT. I'm not sure how you pronounce that, but that's how you spell that word. 3. State domestic legislation may provide romantic cohabitants many of the same legal benefits of marriage. A. Coverage of family health insurance policy. B. Family leave to take care of a sick partner. C. Visiting rights in hospital. Generally have fewer legal protections. Relationships generally have fewer legal protections. A. No modification of alimony. JLM versus SA versus State Farm Fire and Casualty, New York, 2007. But the common benefits clause of the Vermont Constitution included same-sex couples, Baker versus Vermont, 1999, and the Michael Judge Act, 2002, allows the extension of death benefits to domestic partners of firefighters and police officers who die in the line of duty. Okay, so that was the end of the premarital issues. Not a lot to do with like kids, but it's marriage is a type of family, and you have some of these issues that come up a lot. And so I figured it would just be something good to share. Um, I will say personally that in my experience, there's not been a lot of the same treatment for cohabitating or domestic partners as there are for legally married partners, which I feel like in today's time, that's not really right. And there needs to be something done, something written up or something. I don't know. Something needs to be done because there's definitely now an in between just boyfriend and girlfriend and legally being married on paper. And there's a lot of people who are legally married on paper and haven't seen each other in over 10 years. And I don't really feel like that's appropriate. I feel like you haven't been in a relationship with someone, but you're legally married to them, that at some point, you should have to register your marriage every year like you do your car. If you don't want to be married next year, then, that's it. Your marriage rights get revoked. You could maybe pay a fee every year to have to stay married, instead of, oh, well, I can't divorce them because I can't afford to get a divorce. Okay, then pay to be married then. Unable to get married because they can't even find the person to divorce them, which that was the case in two of my relationships, is that the person could not find the other person on social media or through family members or anything to try to even get a divorce, or the person wouldn't agree to a divorce and the judge wouldn't agree to let them divorce the person. It was so many different things. And with my kid's father, they had been separated like 10 or 11 years by the time we met. And so, yeah, I don't know. I just feel like there should be something different in what we're doing, but that's not the main focus here. um, but yeah, there does definitely need to be new laws written in for people who are cohabiting, because I personally not think it's a trend that's going to stop anytime soon, and I don't really feel like it should. I don't feel like we should be forced to legally get married on paper to be acknowledged by the state as a couple. So, anyway, moving on, we're going to be on this section now. Sorry, I looked like I was flipping you off there for a minute. I'm sorry. So we're going to be reading this section, which is marital agreements. So, contract and family law rules apply. Premarital and antenuptial. I've heard of a prenuptial. What's an antenuptial? Is that a prenuptial? I think it is. Contract entered into before marriage. 1. Identifies rights to property either held by spouse at time of marriage or acquired thereafter. 2. Provides for parties' respective property rights upon divorce or death of either spouse. 3. May include provisions for property distribution and alimony rights. Some jurisdictions do not allow premarital contracts to eliminate or modify a spouse's rights to receive post-divorce alimony. 4. Contract defenses generally apply to enforcement. Burden on contesting spouse. So, majority rule. 1. Premarital contracts are valid and enforceable. Special rules apply. 2. General requirements for validity. A contract in consideration of marriage must be in writing and signed by party against whom it is to be enforced. B. Marriage's consideration. C, generally valid if procedurally and substantively fair. D, statute of frauds applies. 3, procedural fairness. Full and fair disclosure of a spouse's assets prior to signing instrument absent fraud or duress. 4, substantive fairness. Reasonable arrangements made for spouse based on situation, age, health, and needs. 5, the test for fairness in jurisdiction specific. Some jurisdictions only require either substantive or procedural fairness, whereas other jurisdictions require proof of both. 6, generally binding on issues of alimony, property distribution, and divorce. Not binding on issues of child custody and child support. 7, additional enforcement factors. Opportunity to reflect upon terms contained in agreement. Opportunity to consult legal counsel on terms. 8, Uniform Premarital Agreement Act, UPAA. 9B, ULA 369. A, provides state statutory model of language governing premarital contracts. B, presumes premarital contracts are valid and enforceable and places burden on party challenging contract validity to prove contract unconscionable. C, has been adopted in some form by at least 27 states. Post-nuptial. Contract entered into during marriage. 1, generally requires written instrument. 2, mutual promises are sufficient consideration. 3, higher standard of fairness applies to enforcement. 4, requires absent of fraud or duress. Full disclosure of assets and fairness for both parties. Okay. So the post-nuptial, it's basically kind of like all the things of a prenuptial agreement, but it's during marriage. So I guess basically you could decide after you get married whose is what's and everything. I guess that would be useful if, say, you and your spouse, after you got married, you bought a car together or something like that. I don't know if this is what this applies to, but you bought a car together and then you agree that, okay, well, who is going to get the car if something were to happen, blah, 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 and then you go and sign that. I'm guessing that's what that is for. Let me check the messages real quick. Make sure I have a good connection. I don't think I have any messages. And yes, I'm sorry if a lot of you are not happy with me reading the law stuff. We are going to get back to normal, not next week, but the week after that. But I am going to be posting a video Wednesday. I'm hoping it'll be up Wednesday. With the way my internet works and the way my schedule is, it's hard to say, but I'm hoping it'll be up Wednesday. So but like I said, we're going to do this one next, which is this isn't a whole lot. Heck, I might just read through the whole marriage thing tonight. That way everything can get back to normal next week and we'll be done reading this. And then if you guys want me to read this, then let me know. And if you don't, then let me know. But what I may do for this one, because it is so long and extensive, like, and this is a quick study. So this is just like a general rule of thumb for evidence. You know, you see how much is, and it continues on the back. So, because this one's so long, I'm not going to bore you guys by reading it live. But what I may do is do, maybe I'll just do snippets or whatever, where I do one video just reading this block and one video just, I don't know. Because I think that will be helpful. But I know that reading this is a lot for you guys to digest. And I'm not even sure if it is helpful to you guys. However, I am going to start reading the big law book very soon. I'm going to try to start reading that very soon. Just that way, so I have more knowledge about family laws and the actual laws, which I think that will cover a lot of general laws. But it is North Carolina specific. And so I'm going to try to read that before I turn 30. I just turned 29 this month, and so I want to have that whole entire thread by next year. And with that, I'm not going to read it to y'all because I really don't think it would be helpful. But I think that it would just improve my ability on this channel to speak to you guys about family law, especially as it regards to North Carolina. So anyway, we're going to continue with this. And like I said, I may just go ahead and read the whole thing tonight, so then I can be done with it and we can get back to normal lives this coming Monday, which will be the first live in December. So, marriage. Uniform Marriage and Divorce Act, UMDA. Definition, 201/1973. 1. Personal relationship between man and woman arising out of civil contract. 2. Valid if licensed, solemnized, and registered, formal statutory marriage. 3. General rule, marriage valid where performed is valid everywhere, rule of lex loci, except if contrary to strong public policy of state. Marriage regulation, constitutional limits on state regulation of entry into marriage. 1. Different degrees of scrutiny for regulations infringing on right to marry. A. Rigorous scrutiny for regulations that are direct and substantial. B. Minimal scrutiny for reasonable regulations that do not significantly interfere with the decision to enter into a marital relationship. 2. Marriage is a fundamental right. State cannot restrict a person's freedom to marry based on race. Loving versus Virginia, 1967. 3. State cannot restrict a person's freedom to marry because he or she has failed to pay child support. Zablocki versus Redhale, Wyoming. I'm not really sure which one this is. This is WI. So whichever state is WI. 1978. 4. Prisoners' marriage restrictions may be constitutional if restrictions are reasonable. Attorney versus Safley, Missouri, I think, 1987. Substantial regulations on marriage. 1. Age. A. Generally voidable marriage if no parental consent for minor under the age of 18. States may provide exceptions for pregnant teen parents of a child in common, where parents are both over the age of 16. I know when I was growing up, that's how it was in Florida. If you were 16 and pregnant, you were allowed to get married without consent. B. Marriage void where statute prohibits marriage under a certain age. Example, under 14. 2. Consent, state of mind. A. Voluntarily entering into the relationship. B. Mutual present intent to be married. C. No fraud or duress. D. State not required to provide judicial bypass where parent withholds consent to unmarried minor's request to marry. 3. Mental capacity. Capable of understanding the nature of the act. 4. Kinship. Statutory crimes such as incest, bigamy, etc. 4A. All jurisdictions bar marriages between immediate family connection. B. Most states apply prohibition to relationships created by adoption. Policy exceptions may exist in reply adoption of M 722A.2D 615 New Jersey Supreme. I think that's Supreme. I think that's something else. Super Court Church Division. I'm not really sure. 1998. C. Consanguinity refers to blood relationships. Affinity refers to marriage relationships. 5. Bigamy. A. Prior existing marriage invalidates a marriage. B. The act of marrying a person while being legally married to another is a statutory crime. C. Enoch Ard Institutes. Generally a defense to bigamy where spouse remarries on good faith belief other spouse has died. Many states absolve bigamy of a person subsequently married after prior spouse missing for a statutory period. 6. Polygamous marriages are void. No constitutional right to plural marriages. 7. Subsequent marriages. A. One marriage at a time by law. B. Presumption of validity of latest marriage. C. Burden of proof on person attacking presumption. D. Void of spouse of prior marriage still alive and not divorced. E. Must be dissolved before remarriage. 8. Other regulations. Same-sex marriage. Generally prohibition by definition of one man and one woman. Equal protection arguments are generally failed. Defense of Marriage Act, DOMA, 1 U.S. Supreme Court 7. A. Defines marriage for purpose of federal law as legal union between one man and one woman as husband and wife. B. A spouse is defined as a person of the opposite sex who is a husband or wife. C. Passed by House renders married gay couples ineligible for spousal benefits under Social Security and other federal benefit programs, but allows state to recognize validity of such marriage on a jurisdictional basis. D. DOMA has withstood constitutional challenges. Wilson versus Aki 354 F something 2D 1298, Florida 2005. E. Many states have enacted state versions of DOMA. F. Raises issue as to whether homosexual marriages should be granted full faith and credit. I. Same-sex marriages valid in Massachusetts. Goodridge versus Department of Public Health. 798 N.E.2D 941, Massachusetts 2003. Connecticut, Harrigan versus Commerce of Public Health, 289, Connecticut 135. Connecticut 2008. Iowa, Varnon versus Brienne, 763, NW2D 862, Iowa 2009. Vermont 2009, New Hampshire 2010, and New York 2011, with additional states considering legalization of same-sex marriages. Canada and several European countries recognize same-sex marriages. Civil union, domestic partnership, common benefit relationships are jurisdiction-specific. Growing number of states provide same-sex couples with protection and rights similar to marriage. Courts have generally refused to recognize these relationships under full faith and credit clause. Not recognized under federal law for purposes of federal benefits, including if FMLA. Legal benefits of recognition do not necessarily transfer to other states. B. Transsexuals split in approach. A. Minority view. Marriage of post-operative transsexual upheld when able to function sexually as chosen gender. B. Majority view. Post-marriage of post-operative transsexual not valid as gender is dictated at birth for purposes of marriage. Procedural regulations of marriage. Statutory marriage. 1. Licensure requirements set by statutory regulation frequently include a waiting period for conscious reflection. 2. Solemnization, ministerial act generally requiring marriage ceremony to take place in presence of religious or judicial official. 3. Health issues. Premarital medical testing serves A. to inform prospective spouse of health hazards impacting marriage, B. to warn public officials of venereal disease, UMDA 203. 4. Premarital education courses. Modern trend is to offer education or counseling services to those about to marry. 5. Covenant marriage statutes provide marrying couples opportunity to elect covenants discouraging divorce. Informal marriages. 1. Proxy marriages no longer permitted. 2. Confidential marriages statutes permit and encourage cohabitants to marry by easing procedural requirements. 3. Common law marriage. Valid where satisfies all procedural elements. A. Capacity to enter into marital contract. B. Present agreement to be married. C. Cohabitation, no defined period of time exists. D. Holding out to public as man and wife and gaining reputation in community as being married. E. Procedural recognition exists in minority of jurisdictions. Yeah, it doesn't exist here in North Carolina. I think they only consider you common law husband and wife if you have been married, or not have been married, but if you were considered that in whatever state you just came from, but not here in North Carolina. Marital issues. General legal principles, state regulation of intact marriage. 1. Common law. Husband owes wife duty to provide necessaries. Wife owes husband duty of comfort and domestic services to the home. Really, I didn't know that. A. Modern trend. Abolish doctrine of necessaries or apply as gender neutral. 2. Common law one person theory. Man and woman become one person for purposes of property. A. Modern approach. Married women's property acts. B. Wife's power to contract with husband and others. 3. Constitutional issues. A. Discrimination based on sex and race prohibited. B. Fundamental right to marry under Due Process Clause of 14th Amendment, I think. It just says A. And equal protection. C. Marriage is a fundamental right. Loving versus Virginia, Virginia, 1967. Procreation or contraception. Government restrictions on access to contraceptive choices. 1. Griswold versus Connecticut, Connecticut, 1965. A. Constitutional guarantees create zone of privacy that bars law forbidding of a contraception or punishing those who aid in such use. 2. Eisenstadt versus Bard, Massachusetts, 1972. State may not discriminate based on marital status regarding distribution of birth control. B. Right to privacy to be free from government intrusion in decision to bear child. 3. Carey versus Population serves the International, New York, 1977. A. State statute banning of sale of contraceptive to minors and is unconstitutional and is a violation to right of privacy. Abortion. Roe versus Wade, Texas, 1973. 1. Right of privacy extended to abortion. A. Liberty guaranteed by 14th Amendment includes woman's decision to whether to terminate pregnancy. B. Qualified right considered with important state interest in protecting health of pregnant women and potentiality of human life. 2. Trimester approach, viability of fetus. States allow wrongful death suits for non-viable fetuses. 3. Woman must be informed of alternatives. Planned Parenthood versus Casey, Pennsylvania, 1992. 1. 24-hour waiting period. 2. Record of doctors subject to public disclosure. 3. New test for constitutional abortion restrictions, whether regulation imposes undue burden by placing a substantial obstacle in the path of a woman seeking an abortion. See also Gonzalez versus Carhart, U.S. 2007. 4. Pregnant teen abortions. A. Parental consent notice may be required for unmarried girl under 18. B. Parental consent notice provisions constitutional for minors. Legislation must provide a judicial bypass procedure. Ayotte versus Planned Parenthood, 126, Supreme Court, I think, 967, New Hampshire, 2006. 5. Statutory ban on use of public employees and facilities in performance of non-therapeutic abortions. Webster versus Reproductive Health Services, I think that's Missouri, 1989. Indigenous women have no right to abortion services through government subsidized health care. Mayer versus Roe, Connecticut, 1977. 6, husband has no constitutional right to notice of wife's pregnancy nor ability to veto wife's choice of to abort fetus. Planned Parenthood versus Danforth, 428 U.S. 52, 1976. Now versus Schindler, 1994. 1. RICO may be invoked to sue protesters who block access to abortion clinics or conspire to stop women from having abortions. Additionally, 8-foot privacy zone, buffer zone is constitutional. Hill versus, it says CO. What is CO? What state is that? I don't know, but CO 2000. Okay, so termination of marriage is the one that we are on now. I know I'm just trying to like fly through these. And that continues over to this side. And then we'll quickly read about domestic violence. But I'm going to check messages and stuff real quick. Although no one is watching right now, so that's good and that's bad. It's bad because I'm not getting any time, and it means that you guys aren't interested in this content, which is fine. It's totally fine. We'll pick up next week when we have more interesting things to say. I'm sure you're going to enjoy the video that I post Wednesday. So there's no messages, so I'm just going to try to fly through the rest of this. I genuinely hope that some of you find some of this information helpful. Because, and I know a lot of this doesn't have to do with CPS, but it does have to do with family. And I believe in protecting the integrity of family. I consider domestic partners or husband and wife, or wife and wife, or husband and husband, or whatever you want to call it, to be family as well. And I am for the protection of that. And so it's good to know these things. So I hope that it helps some of you guys. So we are going to go into termination. We're going to go into termination of marriage. 10 minutes left of how long I typically am on, but I have been on an hour and a half before, so we're just going to try to get through this. This one is, yeah, this one's the longest one so far. So, okay, all valid marriages, including common law, legally terminate by entry of formal divorce. Unilateral divorce. Court has subject matter jurisdiction to dissolve marriages, but does not have jurisdiction over property disputes. 2. Bilateral divorce. Court has subject matter jurisdiction to dissolve marriage and personal jurisdiction to resolve property disputes. 3. Jurisdiction. A. Domicile is basis for jurisdiction. B. Durational residency requirements. I. Statutory residency requirements to obtain divorce. Provides subject matter over marriage and personal jurisdiction over at least one party to dissolve the marriage. C. Soldiers and sailors from adverse court proceedings during active military service. 4. Final judgments of divorce and property distribution are subject to enforcements under full faith and credit clause of Article 4. A, all states give full faith and credit to valid divorce and forum state. 5, committee. Foreign decree generally recognized where judgment is entered consistent with elements of due process and fundamental fairness. Fault grounds for divorce. 1, minority of jurisdiction use pure faith-based system. A, adultery. Voluntary sexual intercourse with person other than spouse, proof of sexual intercourse may not be necessary. Opportunity and disposition sufficient. B, cruel and inhumane treatment. Course of conduct harmful to the plaintiff's physical and or emotional health. C, insanity could serve as both grounds for real and defense of fault-based divorce. D, mental cruelty, course of abusive and humiliating unprovoked conduct that jeopardize plaintiff's life or health. E, desertion, where one spouse intentionally and permanently departs the marriage residence without justification or reason, must be willful and usually for a specified time. I, constructive desertion, when an innocent spouse is driven away from the marital home without reason. F, habitual drunkenness, habit of frequent intoxication. G, some jurisdictions include annulment grounds as grounds for fault-based divorce as well. H, marital misconduct fault may impact financial awards of support such as alimony, may impact property distribution where fault has a negative financial impact on marital estate. Financial impact on marital estate. Defenses to fault-based divorce. 1, recrimination, where both spouses guilty, neither may receive divorce. Oh, I did not know that. 2, connivance, implied or express consent to any fault grounds for divorce that is actually committed. 3, condonation, condone actions of offending spouse. Once act condoned, it cannot later be used as a justification for divorce. So I guess, like, say your partner or your husband or wife, they cheat on you, and then you take them back. You can't say like 5 years after that, well, they cheated on me. It's like, well, that was 5 years ago, and you took them back. So, like, I'm guessing that's what that means. I'm guessing. Not really sure. Anyway, I feel like I should do an entire video just on this. I may do that actually, because this is good. This is the good stuff here. Okay. 4, collusion. Agreement of the parties to create a false fault justification in order to satisfy grounds for divorce. Okay. 5, insanity, where acts justifying a divorce are attributable to insanity. No fault divorce. 1, most jurisdictions are pure no fault, all jurisdictions to their existing fault-based system hybrid. 2, statutory factors. A, parties living separate and apart. B, is irretrievably broken, more than 1/3 of states. C, irreconcilable differences that have caused irremediable breakdown of the marriage, California. D, divorce is granted without proof or fault not relevant to dissolution, but may impact alimony award. 3, traditional divorce defenses not applicable. Separation agreements. 1, written documents setting forth parties' rights and obligations. 2, physical separation must be complete. 3, full disclosure of fair provision for spouse and children. 4, final divorce decree. A, dissolves parties' marriage, returns the party to a status of being single. B, determines custody and visitation of minor children. C, awards child support and alimony. Alimony is gender neutral. D, divides marital property. Division and distribution of marital property. 1, community property, minority in Arizona, California, Idaho, Louisiana, New Mexico, Nevada, Texas, Wyoming, and Washington. I'm assuming this is Wyoming. I don't think there's another W state. A, recognize marriage as partnership. Award each spouse an undivided 50% interest in property acquired during marriage through marital efforts. Carnathan versus Carnathan. 722 SO.2D 1248, 1252. Mississippi, I think. No, that's not Mississippi. Is it? I'm not sure. It's MS 1998. B, property acquired before or after marriage is separate property. C, gift or inheritance deemed separate property. 2, equitable distribution, majority. Excuse me. Did someone message me? Okay. I thought they already went to bed. Turn that on silent so I don't get interrupted again. Property acquired before, after. Okay, blah, 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 blah. 2, equitable distribution, majority. A, property divided equally between spouses. B, marital assets. All property acquired during marriage through date of petition or separation. Title does not control as they are presumed marital. Anglin versus Anglin, New York, 1992. C, non-marital assets, generally property acquired by non-spousal gift, inheritance, separate premarital property, or property directly traceable to any of these sources. D, professional degrees, majority not property subject or to distribution. Minority, increased earning potential subject to distribution. E, generally business goodwill subject to distribution, but personal goodwill is not. F, property distribution, non-modifiable after entry of divorce decree. G, spouse challenging marital property presumption bears burden of proof. H, property of obligations and final divorce decree are generally non-dischargeable in bankruptcy, with few exceptions. Child support and alimony obligations not dischargeable. I, tax consequences of property distribution give recipient spouse adjusted basis of transferring spouse. J, vested and unvested pension rights are generally subject to distribution, distributed as qualified domestic relations order, QDRO, 29 U.S. Supreme Court, 1056 D3A. Alimony. 1, definition, legally imposed support obligations during pendency of litigation, pendelit, and or post-divorce. 2, commonly referred to as spousal support or maintenance. 3, sorry, my ring being cockeyed is bothering me. Okay. 3, Court considers two primary factors: one, need, and two, ability to pay. A, alimony must be awarded at time of divorce. Court generally loses jurisdiction after final judgment. 4, alimony factors include length of marriage, standard of living, education, financial condition of each spouse, age of parties, physical and emotional condition, and marital fault. Fairness is ultimate consideration. 5, temporary alimony, pendent lit. 6, permanent alimony. A, ongoing payments paid permanently and periodically. B, usually associated with long-term marriages. 7, rehabilitative alimony, short-term or defined period to permit spouse to become self-sufficient, may be modifiable where rehabilitation does not occur. 8, lump sum payments, generally not subject to modification. Payer's estate may be liable if payer dies before satisfying obligation. 9, qualifying alimony payments are income to the recipient and tax deductible to the payer. Alimony modification. 1, generally modifiable where court reserved. 3, modified on showing of changed circumstances. 4, party seeking modification generally bears burden of proof. 5, obligation generally ends on death of either spouse or remarriage of recipient. 6, cohabitation of recipient is generally basis for modification. Annulment. Marriage invalidated from onset. 1, treated as if no marriage had occurred. Void ab initio. Relief is retroactive. 2, parties treated as if never married. 3, jurisdiction, either party's domicile, place of celebration, or state with personal jurisdiction over parties. 4, many states provide equitable remedies to spouse where there is good faith reliance on marriage. Putative spouse doctrine. Void or voidable marriage distinction differs drastically among jurisdictions. 1, void marriage. The effect cannot be cured. A, invalid. Treated as if marriage never took place. B, no subsequent act can ratify. C, subject to attack by any third party at any time. 2, voidable marriage. Defect may be cured. A, valid but parties to marry can attack validity. B, subject to attack only by parties to the marriage until death of one spouse. Grounds for annulment. 1, fraud that goes to the essentials, sexual relations and childbearing. 2, material fraud, would not have married but for. 3, duress or coercion, usually voidable. 4, mental illness, voidable if due to temporary insanity, alcohol, or drugs. 5, psychological impotency, voidable. 6, fraud, no intent to be bound. Immigration marriage fraud amendments, which define sole purpose to obtain citizenship or to defraud. 7, age, subject to attack by minor, parent, or legal guardian during minority, voidable until defect of age is cured. Defenses to annulment. 1, equitable defenses, unclean hands, latches. 2, factual defenses, ratification, cohabitation. 3, legal defenses, res judicata and collateral estoppel. 4, Legal consequence of annulment. Majority of jurisdictions provide equitable remedies or access to divorce remedies when marriage annulled. 5. Today, annulment actions are rare as divorce is now readily available. Putative spouse doctrine. 1. Generally recognizes a valid marriage where a person participates in a marriage ceremony in the good faith belief that the marriage is valid. The spouse must not have knowledge of the impediment. 2. Allows innocent spouse to access state divorce remedies even though the marriage is found to be void or voidable. 3. Innocent spouse may also be able to access equitable relief. 4. A putative spouse acquires the same rights as a legal spouse. UMDA 209. Names in the family. 1. Married woman may change her surname to husband's name, may keep her own name, or may use both. 2. Common law rule. If a woman uses a certain name honestly and consistently, that is her real name. 3. Judicial procedure. Upon marriage or divorce. A. Child's best interest dictates. B. In deciding child's last name. Right of privacy does not protect a parent's right to choose a surname that has no parental connection. Henney versus Wright, N.E., 1991. Tort and criminal law issues. 1. Alienation of affection, recognized by minority of jurisdictions. 2. Interspousal immunity doctrine, abolished in majority of states. Bosman versus Bosman, 830, A2D 450. I'm not sure what that is. MD Court Appeals, 2003. 3. Marital rape, no privilege. Criminal Act, People versus Liberta, New York, 1984. 4. Recovery for intentional and negligent torts generally available. A. Tort claims may be compulsory in divorce proceedings. Failure to assert claim may act as waiver. B. No double recovery. Cannot receive alimony and tort recovery for the same act. C. Tort claims may require bifurcation from family division to civil division. 5. Evidentiary privileges. A. Confidential communications, privilege against compelled adverse spousal testimony. Each spouse holds privilege. B. Privilege abrogated in domestic relations and child protection proceedings. Okay. So that was everything on pre-marriage, post-marriage, during marriage, ending marriage. I am going to read domestic violence before I end everything, which is like just a really short little piece. I think on the termination of marriage one, I want to do a video on it because I think that there's a lot of people who would like to know the answers to some of those questions. I know I have in the past before, as far as wondering, stuff about annulments and marriages and divorces and all of those rights. Just some good basic general information. So I may do a video on that sometime. Probably not anytime soon, but at some point I'll probably do that. Just because I do have, I don't want to say a lot, but I do have some law related videos on this channel. And I may actually start doing some of those again. And so I may do a video on that. So real quick, I'm going to check for messages again. my Lord, so many tweets. Okay, so doesn't appear. I'm just going to check over here for messages again. Okay. Yes, I do not believe my battery is getting low. I don't believe there's any more messages. So I will go ahead and wrap this up with domestic violence. No, I'm not going to use domestic violence against you. I'm just going to read about it. Okay, so last but not least, domestic violence. Generally defined as an act resulting in harmful or fear of imminent harm or death. Hold on. Remedies. 1. Broad remedies for spousal abuse and intimate partner violence. A. Primary relief includes injunction for protection against domestic violence, restraining order, protective order, civil protective order. B. Other relief includes no contact provisions, exclusive use of shared residence, temporary custody or visitation of children, and temporary financial support. Ex parte order, temporary order. 1. Immediately available to victim of domestic violence, limited relief gives the ex parte nature of the proceeding. 2. Temporary order must be served in respondent in order to protect respondents' due process rights after service evidentiary hearing set on permanent order. Permanent order, final order. 1. Expansive relief, including the relief granted in the temporary order. 2. Order may be issued for a defined period of time or expire on specific dates set in order. Either party could, 3. Either party could move to modify terms of the order. 4. Mutual orders of protection must have independent fact basis to justify each order. Mutual orders generally prohibited. Enforcement. Violence statutes treat violations as separate criminal acts. 1. No constitutional right to effective police enforcement of terms. Town of Castle Rock, Colorado versus Gonzalez, U.S. Supreme Court, 2005. 2. Beyond state injunctive proceedings, there may be civil and criminal liability for assault and battery, and additional tort liability for intentional infliction of emotional distress. 3. Battered Women Syndrome, BWS. A. BWS evidence may be utilized to explain actions of domestic violence victims. 4. Violence Against Women Act, VAWA, 18 U.S. Supreme Court, 2265. A. Provides full faith and credit to protective order from another state. B. Provides criminal penalties for possession of firearms and crossing state lines with intent to harm victim. C. Provides immigrant women married to U.S. citizens the right to self-petition for immigration status in abusive marriages. D. Courts can assume temporary emergency jurisdiction for a threat of harm or abuse to child's parent or sibling. Okay. So we're done with this. Thank goodness. Talk about interesting, and this is the second week that I've done it. So if you guys are curious about anything specific, or if there's things you've been looking up that you're not sure about, you can always message me the information. and I will do my best to read it over and maybe try to do a video talking about it and explaining it. Because I know that there's a lot of people with me. I'm would think, or at least the people that I've talked to. You know, if any of you guys need help with me explaining what different words they use mean, or you know, whatever, or if you need help on trying to figure out how to get certain information, just don't be afraid to reach out to me and I'll, help you out as best as I can. But anyway, I am very sleepy and I have to get up very, very early in the morning. So I hope that you guys got something out of this video, and look forward. Do not miss it. You are going to love the video that I post this week. I know that you are. And I'm going to do more stuff about that, about him. Do not miss it. You are going to love the video that I post this week. I know that you are. And I'm going to do more stuff about that, about healing. And like I said, this is the series called Becoming the Warrior, because I really feel like that describes my journey. All of you out there, even if you're not related to CPS stuff, I feel like it could help you. So yeah, I'm really excited about doing that series, and I want to do more stuff related to mental health and narcissistic abuse, toxic relationships, different things like that, because a lot of us in these situations are affected by these things. In fact, I think most people in today's society is affected by these things. And so I want to talk more about those issues. So anyway, I hope you guys got something out of this. Let me know what it is you're looking for in content, and be on the lookout for the first video in the Becoming the Warrior series sometime this week, hopefully Wednesday. And I hope you guys have a happy Thanksgiving if I don't hear from y'all before then, and that you have a great night. Bye.